I've noticed a couple patterns among the recent decisions of the Supreme Court. First is how often Justices Sotomayor, Kagan, and Jackson seem to dissent together. Second, how often they seem to just make up facts to make their point. From Justice Sotomayor's dissent: public schools, this court has said, are at once the symbol of our democracy and the most pervasive means of promoting our common destiny. They offer to children of all faiths and backgrounds an education and an opportunity to practice living in our multicultural society. That experience is critical to our nation's civic vitality, yet it will become a mere memory if children must be insulated from exposure to ideas and concepts that may conflict with their parents' religious beliefs. Today's ruling ushers in that new reality. Casting aside long-standing precedent, the court invents a constitutional right to avoid exposure to subtle themes contrary to the religious principles that parents wish to instill in their children. Yet, Justice Sotomayor, just ignore all the facts of the case to promote your advocacy. First, I must point out, the United States is not a democracy, but a constitutional republic. Next, I point Justice Sotomayor to her own dissent where, in footnote 11, she wrote, "Petitioners concede that they have no objection to the books being on the shelf or available in the library." So if the parents did not object to the books being available in the library, how can Justice Sotomayor claim that the parents were concerned about mere exposure? She then takes that false accusation to claim that the court has invented a new right for parents to control exposure to themes contrary to their religious principles. I guess she just ignored the point made by the opinion of the court that the court has long recognized the right of parents to direct the religious upbringing of their children. The result will be chaos for this nation's public schools. Requiring schools to provide advance notice and the chance to opt out of every lesson plan or story time that might implicate a parent's religious belief will impose impossible administrative burdens on schools. The harm will not be borne by educators alone. Children will suffer too. Classroom disruptions and absences may well inflict long-lasting harm on students' learning and development. Now, perhaps, if the MCPS board had not ignored the concern of the parents and trampled their right to control the upbringing of their children, there wouldn't have been so many opt-out requests. If there is chaos for our public school system, it is entirely of their own making. Worse yet, the majority closes its eyes to the inevitable chilling effect of its ruling. Many school districts, and particularly the most resource-strapped, cannot afford to engage in costly litigation over opt-out rights or to divert resources to tracking and managing student absences. Schools may instead censor their curricula, stripping material that risks generating religious objections. The court's ruling, in effect, thus hands a subset of parents the right to veto curricular choices long left to locally elected school boards. Because I cannot countenance the court's contortion of our precedent and the untold harms that will follow, I dissent. God forbid that schools see themselves as assisting parents in the education of their children, not controlling it. I'm not saying there will be no request for opt-outs, but their voluminousness points to the schools indoctrinating our children rather than educating them. After all, parents only opt out because they object to the content the school is teaching. Today's ruling threatens the very essence of public education. The court, in effect, constitutionalizes a parental veto power over curricular choices long left to the democratic process and local administrators. That decision guts our free exercise precedent and strikes at the core premise of public schools, that children may come together to learn not the teaching of a particular faith, but a range of concepts and views that reflect our entire society. Exposure to new ideas has always been a vital part of that project until now. The reverberations of the court's error will be felt, I fear, for generations. Unable to condone that grave misjudgment, I dissent. What today's discussion threatens is the government's monopoly on the education, indoctrination of our children. The idea that the government gets to decide what they are taught and when. And the idea that government owns our children and really allows us to feed and clothe them. It constitutionalizes a parental veto power over curricular choices long left to the democratic process and local administrators. I hate to tell you this, Justice Sotomayor, but the Constitution protects parents' veto power over what curriculum the school can teach their children. The fact that a majority of people voted for the board members who are pushing the LGBTQ agenda on our children as young as 5 years old does not deprive the parents of their right to control the upbringing of their children. And if you're talking about the democratic process, shouldn't a large percentage of parents objecting inform the board's decision?